Well, good afternoon to everybody. Joel, are you going to do any kind of introduction or you want me to do it?
I am. I was
Okay.
glad you got your slides up, and we'll go ahead and get started here today. So first of all, just a couple of housekeeping notes for those of you that are familiar with the program here. Please feel free to send questions in through the chat window or the question and answer pod. If it comes to the question and answer pod, only Marsha and I will see that, and we won't read your name aloud. You're also welcome to pick just my name, and you'll send it just to me, and we'll just say a question has come in and we'll ask it, so you don't have to have everybody know who asked the question. But if you want to send it to everyone, that's fine as well. So please send questions in throughout the presentation, and we'll try to ask those to Marsha whenever we get a natural break. If we don't get a chance to answer it during the session, we will catch up with those at the end and cover anything that we missed along the way. We will have some polling questions today, so we'll ask for your engagement on those things. So just watch for those as we go. And with that, I will, one, introduce our presenter, but two, also mention that this is the first of 4 weeks of classes that Dr. Goetting is going to present for us on a variety of estate planning topics. So please mark your calendars for next week, and also 2 weeks from now and 3 weeks from now, and you'll see more in this series of estate planning. The other thing I'll mention is estate planning rules. Many of them are state specific. So I have asked Marsha to cover Montana rules. In some cases, those will be the same in your state, but not in all cases. So just keep that in mind, that the things Marsha is telling you today are Montana specific, but some of the concepts and some of the rules may be applicable in your state as well. So without too much further ado here, I will introduce Dr. Marsha Goetting, who has been a regular presenter and was one of the founders of this series many years ago now. We started this. So Marsha is a professor and extension specialist here at Montana State University Extension, and really has a nationally recognized education program on a whole variety of estate planning topics. And I'm excited to have Marsha present today. So with that, Marsha, I will turn it over to you.
Okay, Joel. Well, thank you very much. And hello to everybody out there. I am honored to be asked to do some programs on estate planning because if any of you know me, that's my passion. That's something that I really feel is important to people. And here we are, still doing webinars, and I thought we'd be on this road by this time. So I've come up with some participant engagement tools. In other words, we want to keep you interested in what's going on with the seminar. And I have been using lately wildflowers to help tell the story about estate planning. And I like to use the names, and those names can be reminders of some of the things that I want you to consider. So the first one is, of course, why dying without a will is not the way to go. You get that double meaning there, hope so, and maybe you got a chuckle. But let's just start out with another tool that I'll use, and that is the polls or the questions. And I'd like to get a sense of when did you last review your written will? For some people, it's been during the pandemic. For others, maybe it was 3 to 4 years ago, perhaps 5 to 6, 7 to 8, 9 to 10, or maybe it was more than 10 years ago. And finally, you have a chance to say, I don't have a will. So how would I have a chance to take a look at it? So give your answer, and just don't forget to hit that submit button. I know that's something I forget to do when I'm in WebEx sometimes. So when did you last review your will? Okay, Joel, let's see what we've got as responses here.
All right, let's see. We've got 24% saying during the COVID pandemic, 18% said 3 to 4 years ago, and then we've got about 18% that said they don't have a will, and then just some scattered responses to the other ones as well.
Okay. So you said 18% don't have a will?
That's correct.
Okay. Actually, you guys are doing better than the national average because we found that typically 7 out of 10 don't have a will. And I think one's very important, and I'll show you why throughout this program. Okay, another engagement tool, of course, is the chat room. And if you've done webinars or attended some before, you know that those webinars, those chat rooms are very handy. And as Joel said, we want to keep it private. You never know what relative might be on here. And you ask a question and you give your name. Uh-oh, we don't want to do that. So that's another tool. And then I decided to come up with some trivia. And what I've got is wildflower cards. And I thought, well, that would be a good thing for people to have as a prize. So the winner will receive a prize. So what's going to happen here is I'm going to ask a question. You are going to answer it in the chat room, but you only have a certain amount of time to be able to do that. Okay? So here is the very first question. What is the meaning of the term intestate? And the way that we will be able to judge the winner is the very first person that tells us the meaning of that term. So the neat thing about webinars or using WebEx is they actually give a time on these kinds of things. So we will be able to make that judgment, and Joel will be on the lookout to see who entered the correct answer first. So I know you're all hurrying to do that, and I hope if we have a tie, I have more cards. Now, this is my steer's head. And the reason that I use a steer's head is it's perfect because, yeah, you can tell it's really a steer. I used to love during my public meetings to ask people, what flower is this? And most people wouldn't know, and I'd have to go moo, and then they would finally figure it. But what I want to do today is steer you to an awareness of Montana's plan. Now, if you know that your state has the Uniform Probate Code, then chances are it's very, very similar. And we do have now about 35 states that have adopted the Uniform Probate Code. And in Montana, we have a flower called the bitterroot, and that happens to be our state flower. So I'm using the bitterroot to teach a lesson about bitterness. Certainly, maybe you've found in your family there's been bitterness that happens when somebody passes away, and perhaps planning wasn't done, or somebody got into the house and took things. Oh, it's bad. So if you don't have a will or trust, what we have is Montana intestate succession statutes. So I'm telling you the answer right now. Intestate means that you died without writing a will. So already you'll know if you put that answer in there, you are the one that's going to win a card. So let's look at this family. You know, and many of us start out this way with husband and wife, and then they have kids, and the kids get married, and then we have grandchildren. And the grandparents are usually so excited that they now have grandchildren. Well, what we're going to do is follow this family kind of through life. And what happened was really a tragedy in 99 because this particular son died as a result of an airplane crash in Western Montana. Then we had the daughter who died as a result of a car accident in Eastern Montana. Then we had the dad or the grandpa pass away. So what that means is we had mom or the grandma is the one that received all the property there that's in the family. And mom didn't write a will because she said, why should I bother? It's going to go to my remaining son and my grandchildren. And it'll be okay. Why should I spend $1,000 or more on writing a will? So let's take a look and see what happens. So she died in 2010. And the way that I'm going to ask the question is this. You see the red lightning bolt on our grandchild D. I'm asking you, what fraction, if any, will this grandchild receive under the Uniform Probate Code? So again, what fraction, if any? Is that grandchild going to receive nothing, 1/6, 1/8, or 1/9? So those are your four choices. Check one of those. Don't forget to hit the submit button, and we'll see if we're all in agreement about what at least Montana law is going to do. And if you're in Wyoming and if you're in North Dakota, you're also under the Uniform Probate Code. Okay, Joel, let's see what we've got. And yay, I get to see the answers myself this time. That is exciting. And I've got what? If I move my thingy here, I'm going to find out percentages. And I find out 38% of you are saying nothing. And I think that's kind of mean, but that's your choice. And then we have 1/6 saying, or 14% saying a sixth. We've got 14% saying a ninth. Okay, I'm going to give you the answer. Okay, and let's see what that answer is. So you see that 18% got the answer correct. It's 1/9. And you're probably sitting there saying, now wait just a minute. Why would it be 1/9? Well, Montana and other states have this concept that they call right of representation. So let's see what right of representation means. Well, if you go over to the left, you see the turquoise grandchild, and the turquoise grandchild is receiving 1/3. So we could look at that by seeing that child represents the share that dad would have received. Okay, had dad lived, he would have received 1/3. But because he was deceased, it goes down to the son. And you see, it doesn't go to the in-law. The wife does not receive that property. Now we've got the two pink grandchildren. What do they receive? Nothing. And they're upset. And you can't blame them. And you tell them, well, this is the way Montana law does it. But here's the grandchild saying, well, didn't grandma love me as much as she did the other kids or the other grandkids? And you see, that can be hurtful. And then we've got these others that receive 1/9 each. And you see, the reason that it's 1/9 is the daughter would have received a third because it would have gone equally to that generation. And now we split it down. So what happens is a third of a third becomes 1/9. And so that's why that grandchildren received 1/9. Now, grandma could have written a will, and grandma could have left it to anybody that she wants to. And you see, this child, I'm concerned here, that receives a third is under age 18. Well, yes, the child can inherit the property, but there must be a conservator appointed to manage the property for the child. Now, who do you think is going to be appointed as conservator? Probably mom in this case. And so if mom's the conservator, she's going to manage the asset till the kid reaches age 18. Now, I don't know about you, but I'm thinking of myself at age 18. I know that was a few years ago, but at the same time, was I mature enough to manage property, manage assets? Probably not. And what if grandma didn't like the wife? Well, grandma's gone. It's too late to do anything about that. But had she thought of it and been aware earlier, she could have perhaps put that child's share in a trust and then appoint her son as the trustee to manage the asset for that child. And in the trust, grandma could have said, oh, the child gets it at age 25 or age 30. That's up to grandma to decide had she written a trust. Okay, now if grandma had written a will, maybe she could have decided that all of her grandchildren were well off because of their parents, and she wants to leave her asset to her favorite nonprofit. And perhaps that would be the Montana 4-H Foundation as an example. So my tip from the Bitterroot is you need to decide if you want right of representation to apply in your family. Now, those of you that are sitting back there saying, oh, yawn, I don't need to listen to this part, I've got a will. Okay, what I would ask you to do is take a look at that will. Does it say that your property is going to be distributed by right of representation? And if it does, it's doing the same thing that Montana law does. And is that what you want to have happen in your family? I know my attorney asked me, do you want your property to pass per capita or by right of representation? And I just kind of stared at her, kind of doe-eyed, going, what does that mean? And she finally had to draw it out for me because I just didn't understand the wording. So that's why I like to use drawings in my presentation so that people get the concept that this is what right of representation does. And it doesn't mean it's wrong. It just means you need to be aware of the consequence in your own family. So if you have questions about the right of representation, don't hesitate to ask those in the chat room. Now here we have some flowers that are called larkspurs. And I had a lady at one of my meetings say, Marsha, you shouldn't use these in your presentation. And I go, why? It's a neat looking plant. But she said, Marsha, they're toxic. And I go, all right, because there's toxic family relationships that can sometimes result. So let's look at the larkspur family. Let's discover how some of those toxic relations can develop. So I'm using in this example a single individual because we do have single individuals that don't have wills. And so let's take a look. Here's the family. We've got mom and dad, we've got the brother. The brother has 4 siblings and he has nieces and nephews. So we're going to look at this brother and say, what happens if he dies, if he died in 2020? Now, if he did that, who had the priority to inherit his assets? So you can enter that in the chat room. Is it going to be mom and dad? Is it going to be his siblings? Or is it going to be nieces and nephews? So just enter that in the chat room. And Joel, if you would share with me what's happening in the chat room, we'll see what these people are thinking.
All right, we're hearing a sibling, mom and dad, another mom and dad vote, parents vote.
Uh-huh.
More votes for the parents. Looks like most of the votes are for parents, but we do have a couple for the sibling.
Okay, well, good I asked because you guys are right that said parents, and it goes to the parents half and half. And then if we only have one surviving parent, then all of it would go to that particular parent. So I could look at this situation, and I know the situation that the parents are quite well off. It's not like they need the money, but the bachelor brother didn't write a will. So now let's look and see what happens if the brother dies. Now mom and dad predeceased the brother. Okay, so he is now survived by siblings and nieces and nephews. Now who do you think will have priority to inherit that property? So enter that in the chat room real quickly. The brother dies, mom and dad are already deceased. Who has priority? Brothers and sisters, or nieces and nephews? Or I should throw in there the state of Montana because he was not married and he didn't have children. So Joel, what kind of responses are we getting there?
Well, we've got 5 or 6 responses, and everyone so far is voting for siblings.
Siblings. Okay. Well, you are correct. That is what Montana is going to do. Montana law says he died without writing a will. He has siblings, so they're all going to share equally. So that is per capita. Okay, that's what Montana represents. So now let's look at the actual situation. He had a sister that died before he did. He also had another sister that died later on. But still, when he died, his only survivors are his 2 brothers and nieces and nephews. So I have a red lightning bolt on the one brother. And my question to you, and we're going to be able to do this one with a poll, is what fraction, if any, will the Larkspur brother receive? Is he going to receive all of it, 1/2 of it, or 1/4 of it, or nothing? Because everything passes to the state of Montana because he wasn't married and because he didn't have a child. So you respond to that, hit the submit button, and let's see what you think. Okay, Joel, we've got some good answers, I bet. And percentage-wise, let's see what they're saying. Well, nobody voted for all. That's good. I had 9% say 1/2. We have 32% that said 1/4. And we did have 5% saying none. And we've got no answers. Now, I would plead with you, if you're participating, I would welcome you to respond in the polls because it makes it more fun when everybody participates instead of having some folks out there that don't. Okay, so let's see. What is the correct answer to that? 1/3 of you got that answer correct. See? Now, why is it 1/4? Well, remember, we talked about right of representation before. So really, this was my test question to see how good a webinar presenter I am, and doggone it, the majority of you didn't get it right. But that's okay, we're learning together because this right of representation means we look at the brother and we say, hey, brother, how many brothers and sisters did you have? And he would respond, if he could, to say 4. So we know then it's going to be 1/4, 1/4, 1/4, and 1/4. Well, what happens is there is a niece there. Her mom is deceased. So that niece who left Montana 20 years ago doesn't care about Montana anymore. She's in New York City. She's trotting around just la-di-da. She gets 1/4 of this ranch. And we've got the other sister that's predeceased. And let me tell you, her 2 kids, if I just said a mess, would you kind of get the point? And if I said one of them was in Deer Lodge, doesn't that make it worse? They each get 1/8 apiece. Now, everybody tells me he had no respect for his nieces and nephews of those, but he didn't write a will. He died without a will, and therefore, these nieces and nephews that he did not like or respect, they get part of his property. Doggone, I wish I could have sat down, showed him this example, and said, hey, you see the need for writing a will now? You want to make sure the people that you want to receive it do receive the property. And this is going to be a mess because we've got all these owners of the property. And what do you think the niece wants? Oh, yeah, give me my money, buy me out. Oh man, I hope that's not in Bozeman right now because the prices are ridiculous. So therefore, write a will, okay? And again, he could have written a will and decided, hey, I don't like any of those nieces and nephews. Or the nieces and nephews are making more money than he ever thought about, at least some of them, and he could have left it to the 4-H Foundation as well. So my tip from the Larkspur is decide, do you want your property to go by right of representation and therefore avoid some of those toxic family relationships? So we have some resources for you that Joel has posted into the Solid Finances website. We've got a fact sheet on dying without a will, and that's something you can share with your friends, relatives that may not have a will as well. And we also have a fun interactive website that our assistant Carrie did. As a matter of fact, she was the only one on campus at the time that could figure out how to do it. I said, I want to try this. And she did it. And it's so cool because you can go into that and say, are you married? Yes, no, etc. So you might want to take a look at that. Now, these happen to be white mule's ears. And I found those at Big Sky. And now there's a big house sitting where those were. But these white mule's ears remind me of a phrase. Have you ever heard the phrase, Mom or Dad is stubborn as a mule? Well, we said that in Kansas about my dad, I'm sure, several times. And what we want to do is examine the consequences of Dad's perhaps stubbornness as a mule. And here's the dad. You know, his wife died years ago. He has all the property in his name. His two sons are working on the ranch. Okay. And the year is 2010. And dad has said, look, boys, I don't need to write a will. Why write a will, pay that money to do the same thing that the state's going to do? The state's going to give half to child A and half to child B. Well, I'm at the office and I get a call from child A. And they're saying, and she's saying, we're concerned about our dad. We want you to call him up and talk about property ownership. Well, I can't do that as a state employee, but I could say now, have him attend one of my webinars since I'm not out giving presentations right now. So their concern is this. What if dad marries that wow floozy in Billings? Yeah, that's the main concern. They know dad's been dating. Well, come to find out, dad did remarry. I don't know if she was the wow floozy from Billings, but the kids are having cat fits. And you want to know why? Well, what did dad do to show that he loves this woman? He put the property in joint tenancy with right of survivorship with her. And the kids are concerned. But dad says, don't worry. Don't you worry. I wrote a will. And I wrote the will after that joint tenancy was formed. So therefore, the will is going to take priority and just get off my back. Well, no wonder the kids are a little stressed because let's say dad the mule dies. Where does that property go? And I'm sure you're sitting there saying, oh, well, I know this. It's all going to the wife. Yeah. The will does not control that property transfer because it's in joint tenancy with right of survivorship. So she gets it all. Okay. Now, if she dies, now who receives all that property? Oh, yeah, right. Her kids. His kids wind up with zero. This is not the way dad would want to have that happen, but he thinks he knows it all. Well, he's stubborn as a mule, so to speak. And you know, the other scenario could be she, the wife, ends up marrying a hunk, and maybe the hunk's in Missoula. He's a grizzly, for example. Well, let's assume she does that. And to prove her love as well, she puts the property in joint tenancy with him. And then she dies. He receives all the property. The former husband's kids, nothing. Her kids, nothing. Oh my goodness. We really need to know how we've titled property and if it's going to automatically go to the survivor. And what have we done? This gentleman or this lady and her former husband here disinherited the kids. And I don't think that's probably what they wanted to have happen. So what I'm saying about joint tenancy, not that it's wrong, but it may not be the best way to title property if you're wanting to protect your children from a prior marriage. Okay, see, it wasn't a will having an impact in this case, it's the title of the property. So keep that in mind if you've got property in joint tenancy with right of survivorship. Now, I got a new flower here that I'm so proud of. This is called an albino fairy slipper. Yep, found it in Yellowstone National Park. It's the only one I've ever seen. And oh, was I thrilled. At first I thought it was sick, but no, it's real. And this is what a regular fairy slipper looks like. So of course I had to work this into my presentation so I could show it off. And I'm going to look at a married couple that have their property in sole ownership of the husband. And of course, what is the name of this couple? John and Mary Albino. And what they've done is they've told their friends, hey, something happens to us. We want our property to go to the Montana 4-H Foundation, for example. Could have been the Alzheimer's Association, could have been the Boy or Girl Scouts. But this is what I call my traditional Montana family because, it's like the silent generation. Those folks tended to put the property only in the husband's name. And that's what John and Mary have done. And Mary's completely fine with that. It's the job of the husband to do the family. So they don't have children, and neither one of them have written a will. So I'm talking to this couple and I'm trying to convince them of the need for a will. And John is saying, no, don't need a will. It'll be fine. It's in my name. State of Montana will take care of it. Okay, so let's say they're in an automobile accident and John dies immediately and Mary Albino dies 3 days later. Okay, without that will and without having any kids, who's going to receive this property that was in John Albino's name? Is it going to be John's relatives, Mary's relatives, half and half, or the Montana 4-H Foundation because he had witnesses that heard him say, we want the property to go to the Montana 4-H Foundation. So those are your choices. Pick one. And everybody participate if you can. Okay, so we got John's, Mary's, half and half, Montana 4-H Foundation. Okay, Joel, do we have some responses here? Boy, I hope Joel's not taking a nap right in the middle of this program. But he's probably having trouble getting the answers up. That would be me because I haven't done the answers before. Okay, so what we've got here is 19% saying John's, 19% saying Mary's, and only 14% saying half and half. And we do have an individual that thinks because it was vocal and they had witnesses, that it goes to the foundation. No, doesn't happen at all. Let me show you what's going to happen here. What we've got is John's relatives receiving the property. And some of you that said Mary's are saying, wait a minute, he died first, she died 3 days later, so therefore she inherited the property and it would go to hers. Well, no, that's not what happens because Montana has a 120-hour survival requirement. Montana says you must survive 120 hours to inherit property. Now, otherwise, the heir is treated as predeceasing the decedent. How do you like that legal language? But the end result is Mary is treated as predeceasing John. Why? Because of that 120-hour requirement. So John is saying, yep, I still don't see the need for a will. And I thought, John, I'm going to get you yet. So I said, well, John, let's just take this example one step further. And John, what if you die first and Mary dies on the 6th day or 7th or 8th, whatever? Now who receives the property? And I just love that expression on John's face when I said, Mary's relatives receive it all. Guess what? He was excited then about writing a will and understood the need for that will. So John and Mary can communicate about what their goals are for their estate plan, and maybe they don't have any relatives that they want to leave it to, and they can write a will and, yes, indeed, leave it to the 4-H Foundation. Now, let's look at the Jones Columbine. Any of you that are kind of familiar with flowers know that columbines tend to be kind of tall and they go in the wind like this. Oh, not these. We hiked in Glacier National Park, only it's the one in Canada, Waterton, and found these, and they're about yay tall, and they're in a scree pile. So we had to crawl up to them. Anyway, love those flowers, but it makes me think of the Jones couple, and it happens to be John and Mary Jones. Okay, we still have that sole ownership, and oh, in this case, we've got some survivors that are John's parents. So let's see what this looks like in a drawing. And we see that John and Mary Jones have $500,000. And we want to see in this case, how much will the surviving spouse receive because the husband's parents are alive. He has all the property in his name only. Okay, so let's take an example. Is she going to receive 150,000, 325, 450, or all 500,000? So we're looking at how much the wife is going to receive if the husband dies with all the property, all 500,000 in his name. So what are we going to receive, or she in this case? Okay, Joel, does it look like we're getting a good response here?
We are. We got a couple more in progress, and then I'll close it here and share the results.
All right.
And just like last time, it's tabulating results, so we'll have to wait. It says 14 seconds.
Oh, okay. I thought a computer would be quicker than that. I'm sorry to rush you. I didn't realize that.
It didn't need time to think at the beginning, but apparently it's needing a little more time now.
Uh-huh. Maybe it's getting tired.
All right,
Okay,
there you
let's see
go.
what you say. Okay, we've still got some that aren't responding, but of those that you that did, we've got the answer of 150, see, and all 500,000. So let me take a look and show you what happened here. This one surprised me when I was studying to get this information out for people, because what we've got is a Montana law that says if parents are living and there are no children, the way the property is divided is the first 300,000 to the surviving spouse, and then 3/4 of the balance, parents then receive 1/4. So what that means in this case is the wife receives 450 and mom and dad receive 25,000 each. Isn't that amazing? So that's what the legislature did in this case. Now, had John and Mary put that property in joint tenancy with right of survivorship, we know what would happen. It would all go to the wife. So she would receive the full $500,000. So my tip from the Jones Columbine is really couples need to decide, is sole ownership the best for your situation? You need to look at the consequences of that. And we have some of our older generation that could benefit from some examples that we have on our website, for example. Now we've got the showy Jacob's ladder. Okay. And this is the Jacobs family. And word-wise, we know there's a spouse, there's the parents, and there's children. So if I draw this out, we've got mom and dad, the couple and their children, but it's all in the husband's name. So now, what fraction, we won't use dollars, we'll just look at fractions. What fraction, if any, will each of Jacob's children receive? Will they receive 1/6, 1/3, 1/5, or will they receive nothing? Okay, Joel, let's see, let it take its 14 seconds to calculate. Oh, we got them already. So we've got 25% that are saying nothing, and then we've got 5% equally for the rest of those. So let's see what the answer is here. Those of you that said this, thinking the children won't receive anything because the spouse receives it all. And then that is exactly what happens. If they had $800,000, for example, that would be what was, so it's all, no fraction. So consider, though, what would happen if this spouse remarried, which we saw some examples of that earlier. Now I have a common bear grass, and we have a common butterwort, and a common blue-eyed grass. I think I'm trying to tell myself something here. Common. Tenancy in common. You see, this is another way that when you have more than one person, you can title the property as a tenant in common instead of joint tenancy. And what a tenancy in common is we're going to say it's an undivided 1/2 interest. We don't take a home and draw a line down the middle and say, well, he owns this half and she owns that half. Same way with land, it's tenancy in common. So if we have a tenancy in common and we have an individual pass away, what we're going to do is only look at that value. Okay, so that would be the $250,000. What would happen? Well, we go back to that same rule about the surviving spouse receiving the first 300,000. So in this case, it means she's going to get the whole amount. You see, she gets 250, but she could have got 300,000 had there been more. Well, if we do 800,000, then we got a different situation. She gets the first 300,000 plus 3/4 of the balance, and then mom and dad split 1/4. So that's the way it would be divided in that case. And maybe the husband wants her to get it all. Well, you better write a will or she won't. Okay. So we can see quickly that how the property's titled has an impact on how much a surviving spouse receives. And it also, the dollar amount that's there too, because of what Montana has done to increase the amount that the surviving spouse receives. But if we have a high enough estate, we've got 3 different amounts that could go to that surviving spouse, depending on how the property is titled. So keep that in mind. Look at your deed or title and be sure that you know what it is that you have and that you do indeed understand the difference between joint tenancy and tenancy in common. Here's the old man of the mountain. Yep, there's a flower by that name. And there is a misperception out there that estate planning is only for old people. You got to have white hair before you plan your estate. No, youth on age. Yeah, that's the real name of a flower. They think they're invincible. They don't think that they're going to die. But death can result at any time. We've got cancer. We have people in Bozeman that have died, fallen off, doing rock climbing. And now we've got, doggone, Delta. We got Omicron, and we've got lots of things happening. And you could end up dying from that. So we want you to look at that. Our website, and we call it an interactive one because it asks you questions like this. Do you have one or more children? And you click, and then are they from this marriage or that marriage? You go through, you click all these answers, and then there's a result there that shows you exactly how the property is going to be divided. So we invite you to go to that website. We've got 13 single situations, we got 22 marital situations, and we even get into the toughies where you've got his kids, her kids, and our kids. My goodness. Yep, there shows you that. And if you got somebody in your family that doesn't think they need a will, show them something like this. They might be interested then. So take advantage of that website. You can even just use your favorite browser and say "Dying Without a Will in Montana," and it'll take you right there. We also have a CD for those of you that don't have reliable internet service. And I've had folks from Roundup, for example, say, "Oh, please send me the CD because our internet service is just not dependable." So the tip from the youth on age and the old man of the mountain is, if you don't have a will or trust, use the Montana website or RCD to find out where the property is going. Well, my observation from the lady slipper is time has slipped away really fast. And I hope I steered you to an awareness of Montana's plan for the transfer of your property. It's going to happen one way or the other, and you can take control. And then, what is the meaning of the term intestate? Joel, have you picked out a winner for this particular answer?
We do have a winner, but I won't share her name on the air, but we'll reach out afterwards and get that prize to you.
Okay, so you all can be in suspense about that. And if you don't have a memory like this elephant's head, don't forget, we've got 49 mock guides in the estate planning area, and those are also available at your county extension office. Now, next week, what we're going to be talking about is who gets grandma's yellow pie plate and grandpa's watch. So stay tuned for next week. Okay, Joel, do we have some questions in the chat room?
We don't have any questions at the moment, but I encourage people, if you have any questions, now's the time to send them in. I'll just give a couple reminders and give people a minute to send those in. First of all, again, next week on Wednesday, we will have Marsha back with us, and we're going to talk about all those things that are important in your house that don't have a title, whether it's a yellow pie plate or a desk or a table. Those things are all going to be covered next week. And then 2 weeks from today, we'll also have Marsha back, and she'll be talking about avoiding probate and some tools to do that. And finally, our fourth session is going to be about healthcare, financial, and estate planning things, and dealing with relatives that may have memory care issues. So that'll be kind of the fourth component in our series here. So Marsha, I am not seeing any additional questions. Do you have any final comments you'd like to share?
Well, once again, thank you for participating today, and I look forward to seeing you next week, and we'll discuss some of those things that Joel talked about, because I see more family fights sometimes over those things than other things. So tune in next week, and I'll see you then.
And Marsha, we do have a couple questions that came in. So since you're still here, we're going to address these. So question one, as a now single parent, I've had a child be adopted by someone else. Where does this child fit into my estate plan?
Okay, you can write a will if you want to, and you can recognize that child. Once they've been adopted by another family, then technically they're not your child anymore. So therefore, the state of Montana is not going to recognize that child. So you have the responsibility, if you want to, leave something to that child, and then consider, do you want to leave it just outright and have a conservator appointed, or do you want to put those assets in a trust and name a trustee that you trust to do this and manage that, and you've got control. And that's one of the things that we'll talk about later as well.
All right, and Marsha, this is a follow-up from the same question. Does a trust serve the same purpose as a will in this particular case?
You know, the thing about trust is, I have some attorneys say everybody needs one. No, that's not necessarily true. It kind of depends on your situation. And we've got living trusts that have a function, and we've got testamentary trusts. And there's different reasons to use those. And those of you that are interested in trusts, we do have 3 mock guides that you might want to take a look at. One is on living trusts, we've got one on testamentary, and then we've got one on bypass trusts. And we simply don't have enough time to get into detail about those. But if I could free advertise here, we're going to be talking about those on our Fabulous Fridays. And Fabulous Fridays will start on February the 4th at 10 o'clock. And you can go to the website, just go to Fabulous Fridays Montana, and you'll see when we're having the session on trusts. And you might want to participate in that one and get a full hour of everything you wanted to know and then some about trusts. Okay?
All right, so one, I put the link to that Fabulous Fridays in the chat window, so feel free to follow that. We do have a second question that came in, and I'm going to kind of reword it here to hopefully make it very clear. So we have an adult that has children who is single. They have a property and sole ownership and a will that has all the proceeds going to that individual's children. They remarry, but they don't have time to change the will. And does the new wife get anything if this individual passes away?
Well, what happens in Montana is, you're leaving everything to the kids, but now you're married. Well, your married individual can say, I have a right to an elective share. In other words, Montana doesn't let you totally disinherit your spouse, which is what you're doing. So what we may want to do is make time, or did we have a premarital agreement with that individual that says, all your property goes to your kids, or can you have a post-marital agreement where the spouse is agreeing, yes, your property goes to your kids, my property goes to my kids. There's definite estate planning aspects here that remarried families need to take a look at. And that bypass trust Mont guide is something that you'll want to take a look at, because in that, Joel has given some examples that might just be perfect for you and give you some ideas of what you could do.
All right, well, thank you very much. It looks like we've gotten through all of the questions and we're right at the end of our time today. So let me thank Marsha for sharing her knowledge with us today. And again, mark your calendars. We will see Marsha back a week from today and we'll all learn a little more about estate planning.
Okay. Bye. Thank you.